Hello, this is Matt on the Moon Lambeau channel. A former SEC official says that it's unlikely Ripple's going to win the lawsuit against Ripple, as in things not going to go well at summary judgment. And John Deaton, attorney John Deaton, read the article that this former SEC wrote on this exact topic, and he had an opinion that I want to share with you. Firmly disagrees with the analysis. And I think you'll find his take rather interesting, as did I. I want to give a shout out and credit to my fellow XRP YouTuber first, Crypto Eddie. She's the reason I came across this article written by this former SEC official. He wrote it on LinkedIn, and then John Deaton came across it as well as a result of this. So always want to give credit where it is due. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here you can see, just a bit earlier today, my fellow expert YouTuber Crypto Eddie wrote the following, sharing this article. The most recent SEC vs. Ripple decision by Judge Netburn, who is the real winner? Written by the former chief of the SEC of Office of Internet Enforcement. And you can see right here, just to give you a little preview, and there's more from John Deaton, but he said his first response to this, just a couple hours ago after reading this article, was, this article is a case study on confirmation bias. So clearly, you'll see as I go through this, this guy doesn't think things are looking good for Ripple. He thinks that this former SEC guy, he thinks that that Ripple's legal team has definitely made a notable mistake in the way that they're pursuing their defense in this case. And John Deaton firmly agrees. So we're going to go through this. It's not that long of an article that John Reed Stark wrote here. Here you can see John Reed Stark is former chief SEC Office of Internet Enforcement. Again, so that's him right here. And I think you'll like John Deaton's response, and I got a few things to say about it too. But anyway, here's what a former SEC official John Reed Stark had to say. Hot off the presses. Nice win for the SEC and their Southern District New York litigation with Ripple. The motions stem from Ripple's challenge that Ripple officials were objectively reckless in believing that XRP was not a security and that Ripple was on fair notice that XRP was a security. Part of their claim is that they relied on the 6/4/18 speech. And by the way, that's wrong. That was actually June 14th, 2018. I know that without even double checking it, so just correcting the record there. Not a huge deal, but correcting it. Part of their claim was that they relied on that speech by the SEC official Bill Hinman on whether Ether is a security. So look, and I'll pause here and note that attorney Jeremy Hogan, whether news is good or bad, he's going to report the truth, and so he sort of agrees with that part of John Reed Stark's assessment in that this was better for the SEC than Ripple. You may remember attorney Jeremy Hogan, rather, and I shared this on my channel, and he's talked about it publicly. He said, if anything, this is like SEC just got a score of 2 on this, and then Ripple got 1 point, effectively. So not that Ripple didn't get anything, it's just that the way things played out, and I've already talked about on the channel, so I'm not going to delve in tremendous detail in this video. On the whole, yes, it does seem that this was a bit better for the SEC than Ripple, but most of what's been happening in the last 12 months has been better for Ripple than the SEC. And so how's this all going to come out in the wash? I'm not convinced that anything has substantially changed to this point. But anyways, piece continues. Be wary of headlines calling this decision a victory for Ripple. Yes, Magistrate Judge Sarah Netburn ordered the SEC to produce fact documents related to fact gathering from third parties, though to the extent that any portions of the notes expressly reflect the author's own thinking or reflect deliberations or communications among SEC staff during the meeting, the SEC can redact such portions. That is no big deal and always the case. With respect to most of the contested documents, the judge sided with the SEC, citing various privileges and protections, many of which seemed painfully obvious. Here's where Ripple may try to spin the decision. Judge Netburn did order the SEC to produce certain emails concerning the Hinman speech or draft versions because those emails concerning the speech or draft versions are neither pre-decisional nor deliberative agency documents entitled to protection. This seems like a Ripple win, right? Not so fast. Unless the emails contain a smoking gun, this is a Pyrrhic victory for Ripple at best. And by the way, I was not familiar with this word Pyrrhic, Pyrrhic, so I just looked it up before recording the video. But it means basically it's something that was won, but at too great a cost to the point where it's not worth it. And so there you go. I learned a new word today. So he said this is a Pyrrhic victory for Ripple at best. In fact, in my view, Ripple may have shot themselves in the foot by waging this battle. And here's why. So think about it. He's talking about how this was not a great victory for Ripple unless there's a smoking gun in these emails, which he doesn't seem to think is likely, in which Bill Hinman was sharing drafts of his speech, his Ethereum free pass speech, before he gave it on June 14th, 2018. And he's saying, unless there's a smoking gun in there, which probably there isn't, this was a losing battle for Ripple to fight. And here's why. John continues. This is John Reed Stark here. In her opinion, Judge Netburn writes that Hinman's speech was his own and did not represent the opinion of the SEC, stating, quote, although Hinman and the SEC admit that agency staff discussed his speech, it appears, it appears that his speech was merely peripheral to actual policy formation and not an essential link in the SEC's deliberative process with respect to Ether. In other words, Hinman's speech had little to do with the formulation or exercise of SEC policy-oriented judgment, which means, number one, it makes it harder for Ripple officials to argue that their reliance on the speech was not reckless, and number two, weakens Ripple's argument that anyone at Ripple acted reasonably when relying on Hinman's speech. Now, this is a key point because we're going to come back to that in just a hot minute here. And then this guy wraps up by stating, this should come as no surprise. Every SEC official begins every speech with a disclaimer that the views are their own and not necessarily those of anyone at the SEC. I have done it 100 times. Every SEC lawyer worth their salt knows that relying on a speech is not a defense to an SEC enforcement action, but best worth citing during the SEC's investigative phase when seeking a little rackmoans from the SEC staff. And by the way, it's another word I didn't know, but I Googled it. And apparently it means pity, rackmoans. I don't know. I'm learning new stuff left and right here, folks. Left and right. Can you believe English is my first language? Anyway, then he writes, good luck, Ripple, and kudos for trying, but hanging your hat on an SEC speech to win your motion to dismiss or motion for summary judgment just became even more of a long shot. And so here is what attorney John Deaton had to say. And again, the first thing I shared with you before reading that is John Deaton said, this article is a case study on confirmation bias. And then somebody asked him to explain further. And John Deaton did. He wrote the following. The ruling is more technical than substantive. She's referencing Judge Netburn, of course, she accepted the speech as personal opinion and not as an official statement by the SEC. He claims this weakens Ripple's reliance on it as guidance. Wrong. It's an objective standard, not subjective. The market considered it guidance. The issue is what impact the speech had on the market. Hinman said, we at the SEC don't consider it a security. Articles were written about the SEC declaring Ethereum not a security. Lawyers who negotiated with the SEC said, if you're a little more decentralized than Ethereum, you're golden. So let me break this down for you. Here's what's going on. Even though Judge Netburn decided that Hinman's Ethereum free pass speech on June 14th, 2018 was just his personal opinion, and she did decide that it's just his personal opinion, that does not mean that market participants didn't perceive it as market guidance and act as if it were official SEC decree. This is easily provable by looking at headlines from both crypto media and mainstream media. The reports were not that an SEC director thinks Ethereum is not a security. The media reports were that the SEC has determined Ethereum is not a security. And the SEC was well aware that the market was collectively interpreted Hinman's speech as an official SEC doctrine, but the SEC did nothing to correct that reporting. False reporting, right? If what the SEC is saying their position is, what their position is, if that's actually what they believe it is, well, why wouldn't you help the market and be like, whoa, why are you guys reporting this all wrong? This is just one guy's opinion here. Why didn't they do it? Doesn't that seem a bit reckless? And why are all these market participants all perceiving this the same? And if all of them are perceiving it the same, is it a subjective opinion or objective opinion? And this gets to the legal point of this all, because the judges made it very clear. It's what objectively is true. That's what matters. That's what the judge has said multiple times during the pretrial hearings, right? And so Deaton, Attorney John Deaton, is making the point that how the market reacted and what an objective, reasonable response would be is a separate issue from whether or not Hinman's speech was just his personal opinion. Two separate issues. And so even if it's just a personal opinion, again, look at how the market responded objectively. And Ripple was just one player in the space. That's it. But they all responded the same, did they not? And what does that tell you about the regulatory clarity out there? What does that tell you about fair notice? I think you get what I'm getting at. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.